Good morning.
Good morning,
You
Mr.
can hear me?
I can hear you just fine.
You need to unmute yourself, Mr. Serlick.
Good morning.
All right. Before we get started, I just wanted to make sure that the court reporter is able to communicate with Ms. Bendel. Okay.
Yes, I can read you what you're saying in real time. And
Okay.
we should have court watchers as well.
Your Honor, I can hardly hear Miss Bendel, though.
Yeah, I'm having trouble hearing you as well, Ms. Bendel.
I'm sorry, you can't hear me?
Yeah, you're kind of low. Your voice is kind of.
Okay, well, all of my settings are correct and my Zoom works all the time and everyone can always hear me and I'm using the same equipment.
That sounds a little better. Is that better, Ms. Condit?
I do the
Yes, if
same
she'll
thing.
just speak up a little bit louder when you speak, it might help us.
Certainly, I can talk louder. Is this better for you?
Thank you very much.
Okay.
Let's
This
get court
is.
watchers in.
Yes. Before I do, I just wanted to find out who the proposed witnesses are because oh, Pete Arnold.
Correct.
Okay, so we'll wait
Everyone else is court watchers.
right. I will let them in.
Okay.
And Mr. Serlick, do you have any witnesses?
No, not today.
Okay. All right, so I'm gonna let everyone in except for Mr. Arnold because he's gonna be a witness.
Correct.
Crystal Kolpak, Fiona
Mhm.
Wayne, Sabrina.
Let them all in, sir. They're all across this nation.
Okay.
There's no need to read all their names. They're across the entire nation. In fact, some of them might even be across the globe.
I just don't.
And
I just
I
want to
do
make sure they're
have-
not going to be witnesses.
No one is a witness except Pete Arnold. Just like last month, I told you exactly who my witnesses are. You do not need to read every single court watcher's name. No
That's
other person in Circuit 7 does that. You're the only one that seems to be doing this. And I do want to let you know, on the record, I have a written script statement, just like I had last time, that I'll be reading before we get started. I want to remind everyone, this is my hearing against my abusive ex-husband, Justin Serlick, not the other way around.
All right. Can I have the parties raise their right hands to be sworn, please? Do you each solemnly swear or affirm that the testimony you will give in this case shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
I do.
All right. So we are here on a continuation of a hearing. This is on the former wife's amended supplemental petition for modification of domesticated foreign custody order. It's document number.
Except there's another piece to this that we need to address that you illegally dismissed. You do not have the authority to dismiss it. So
I'll
we
get
will
to
be
that.
talking about that.
Yeah, I'll get to that in a second, Ms. Bendel.
Good, because we absolutely will be discussing that today.
Okay. And the other document was the former wife's supplemental petition for modification of child support, document number 62. Now, there was a third.
Yeah, DIN number 35 that you illegally dismissed. You do not have authority to dismiss anything by a judge. And that has been sitting stagnant since July 24th of 2024. And that is to give me immediate access to my children in my home. Emergency visitation. And it has been sitting for almost a year while my children are being neglected and abused by Justin Serlick. So I'm going to read this statement that I've had prepared for over a month. Okay? And then we can get started with all the exhibits.
You want me to address that particular motion first, or do you want to read your?
Why don't we let me read my written statement that I have had prepared for over a month? Again, I'm going to remind everyone, this is my case against Justin Serlick. You need to start letting me run my case like I'm an attorney because I'm pro se. So you need to start letting me actually talk. So I'm going to read my prepared statement, okay?
You want to use this as your opening statement?
This is my opening statement. I've said that
Okay.
3 times now on the
Okay.
record.
Just keep in mind, Ms. Bendel, opening statements are not evidence. It's just your summary of what you
No,
believe.
that's fine, but it's also being recorded and court watchers are watching. So I'm fully aware of how court systems work. I'm educated.
All right, go ahead, Ms. Bendel.
Thank you. Mr. Alvarez, before we start going through my 273 pages of exhibits I filed for this hearing, I want to state on the record that I filed 282 pages at the Daytona Courthouse Thursday, March 20th before noon, and only the first 9 pages showed up in my docket, which was only the breakdown of each exhibit. My 273 pages of evidence showing Justin Serlick neglecting, abusing, and exposing my children to drugs was not filed into my docket.
In the grave.
You need to mute yourself. Court
If there's
watcher, you need to mute
yeah.
yourself.
yeah, if there's a court watcher that just
If
spoke,
there is a
you
court
need-
watcher that can't mute themselves, you need to remove them. You have my permission, because odds are it's probably one of the Serlick's friends trying to interrupt me. Back to what I was stating. This is completely unacceptable when it comes to minor children's safety and welfare. I had to e-file them yesterday, March 24th, 2025, to make sure they were in my docket, since it's clear someone is intentionally not filing my documents. Second, I want it to be on the record that since our last hearing on February 25th, 2025, I am now a 2026 candidate for Florida legislature, and I will be using my case as an example of the extreme issues in our local court system and how people in positions of power are not doing the job they swore an oath to do while collecting taxpayer money. Third, I want to remind everyone that this is my case against Justin Serlick, not the other way around. The evidence I've submitted is so severe that after I present it to you today, I expect it to be forwarded to the state's attorney's office for review for charges against Justin Serlick. I also wanted to be clear, I have had 0 meaningful contact with my own biological children since they were dumped down here in Daytona, Florida, August of 2021. He is using my children as a weapon to continue abusing me while he neglects their education, mental health, and most likely their physical health, while exposing them to drugs in front of the entire world on TikTok. Mr. Alvarez, you have a legal, moral, and ethical obligation to act on this evidence immediately. And I am making it clear that I expect to be able to pick up my children in a neutral public meeting place with Peter Arnold present as a witness and have immediate access to my children in my own home with Pete Arnold. As if passing a fingerprinting background check with Volusia County Schools and BCS putting me in classroom 913 at New Smyrna Beach Middle School to teach 121 other people's children is not more than sufficient evidence I have 0 criminal background, proving that there is absolutely 0 reason to keep my own flesh and blood from me. I am here to inform you that I have several other tricks up my sleeve to prove that what you are doing is highly illegal, and there is no reason other than abuse of our judicial system to continue keeping my own children from me. The abuse of the judicial system has gone on long enough. My children need help. Thank you.
Mr. Serlick, did you want to make a brief opening?
Sure. I don't have anything prepared, but just so that the court is aware, there was a report put in with the Florida DCFS office yesterday. They came to my house, spoke with my children, and I even discussed the TikTok issue that she's bringing up, and there was no found problem and no found of abuse. And this is the second time that I have been attacked in this manner, where false reports of abuse have been submitted to the state as an attempt to attack me.
Judge Sazia Warren,
Anything-
November 19th,
Hold on, ma'am.
2024,
Ms. Bendel?
informed me in front
Ms. Bendel?
of his attorney and Peter Arnold to file a DCFS report. I'm a mandate reporter as a registered Girl Scout leader. I'm also a mandate reporter because every Floridian in the state of Florida is actually a mandate reporter, as well as the officers that showed up at my house on Friday to attack and abuse me through this corrupt child support order that was done under the table by Serena Balducino. I want everyone to be aware that's watching that I am about to sue everybody involved in this corruption case.
Ms.
I have
Bendel,
every right to file DCFS reports, and the judge even told me to do so.
Ms. Bendel, please don't interrupt. Mr. Serlick is giving his opening statement. After he's done, we'll commence with the evidence, but please let him finish his statement, okay? Go ahead, Mr. Serlick.
Thank you. I am doing the best that I can as a single parent to try to raise the children when the other biological parent has absolutely refused to provide any type of supplemental child support for their needs. I would also like to request that the court conforms and adheres to the decorum of the courtroom rules and issues penalties for those that do not continue to follow the decorum.
All right.
And then I do apologize, one final statement.
Let's start
There's
going
been,
through the exhibits. We've only got an hour today. We need to start going
Okay.
through the exhibits.
Yeah, briefly, Mr. Serlick, go ahead.
Miss Bendel believes that I have an aspiration to get back involved with her romantically. That is an absolute false, and I want it
This is my
stated that
hearing
there is
where
no
we
interest.
are going through evidence. He needs to stop chewing up my time. This is about the safety and welfare of my children. Let's start going through the evidence.
All right, Ms. Bendel, did you want to start with a witness first?
Are we going to start going through the evidence?
Yes, ma'am. We're on your case now.
Great.
Do you want to
So
testify
let's start
first?
going through the evidence.
Okay, go ahead. Oh, before we start, there's another person named Andrea in the waiting room. Is she a court watcher?
They're all court watchers, sir. Stop wasting my 1 hour.
Okay, I've admitted her now. Go ahead.
Let every single court watcher in. Every minute you are chewing up, you are taking away time of me protecting my children from this monster.
Go ahead.
Stop
Ms. Bendel.
wasting my time. I have a lot of evidence and we need to start going through it, Mr. Alvarez.
Go ahead.
Okay, so we are going to look at Exhibit A, correct?
Yes. Did you provide copies of these exhibits to Mr. Serlick?
Yes, sir. He's got multiple copies of it. Stop wasting my time. We need to start going through the exhibits.
Yes, ma'am. Go ahead.
Okay. Exhibit A is DIN 110, Order of Referral to General Magistrate by Judge Sandra C. Upchurch for DIN number 23, number 35, and number 62. And DIN 122, Order of Recommendation to Dismiss number 35 without a hearing or seeing any of Heather Bendel's evidence of neglect and abuse to the minor children in question. In the state of Florida, general magistrates do not have the authority to dismiss judges' orders. Therefore, we are to immediately hear Heather Bendel's motion for immediate visitation filed by Heather Bendel's attorney, Rick Brown, July 24th, 2024, as Justin Serlick has been withholding any and all contact between Heather Bendel and her minor children since August of 2021, while actively neglecting and abusing the children right in front of everyone's eyes. Heather Bendel has now lost 5 full years with her biological children that she will never get back due to collusion and corruption in this case since September 2020, when Heather first opened her case in Illinois. And this is continuing in Florida, which is allowing Justin Serlick to use the minor children as weapons to continue abusing Heather Bendel. This is extreme child abuse and child neglect. And Heather Bendel is now requesting criminal actions be taken by Florida Circuit 7 against Father Justin Serlick, and this court immediately allow Heather Bendel full authority to pick up her children and get them the help they desperately need, as this has gone on long enough and these children need intervention immediately. Do you have any questions about that, Mr. Alvarez?
Ma'am, you don't ask the court questions. You just present your evidence. Did you want to
Okay.
present another exhibit?
And what are you to say to that who illegally dismissed my access to my children immediately?
I thought you didn't want me to address the exhibits one by one. I thought you wanted to get.
When did I say that?
Okay. With regard to Exhibit A, the motion for temporary time sharing, since this is a post supplemental petition case, under Florida law, the court is only able to address.
Yeah, sir, you don't get to illegally dismiss me being able to
Ma'am.
visit with my children immediately.
Ms.
You
Bendel,
don't get to do that. That is not your job. Your job is to refer to the judge and that's it.
Ms. Bendel, please don't interrupt me. I'm trying to explain to you why I ruled as I did.
I was capable of reading your explanation on the paper, sir. What I'm telling you is you don't have the authority to do that.
Well, your motion, the court did not determine that your motion for temporary time sharing was an emergency. The judge could have heard it.
Nothing was determined, sir. It was referred to you.
Ms.
And
Bendel,
then you immediately dismissed it. Nothing
Bendel.
was determined. It was referred to you to address, and then you immediately dismissed it the moment it was referred to you.
I'm not saying that
That is illegal. You don't get to do that.
Ms. Bendel, I'm not saying that I'm not addressing
Okay,
your
you're
motion
you're
for
on
temporary
recording
time
for my
sharing.
lawsuit to sue you, so we're gonna move on now. Exhibit B, all evidence of child neglect and abuse that was filed by Heather Bendel in DIN 83, December 16th, 2024, that was to go before Judge Stasia Warren, December 17th, 2024, but was never addressed, which was recorded by multiple third parties. Then December 20th, 2024, Judge Stasia Warren recused herself from Heather Bendel's after she did a public records request with Mark Weinberg. So the 12.941D emergency custody order just sat ignored. Once Judge Sandra C. Upchurch was assigned to the case, Heather Bendel submitted another 12.941D emergency custody order with the exact same evidence of severe neglect and abuse that was heard on January 8th, 2025, and then denied by Judge Sandra C. Upchurch. And her reasoning was, I am not familiar with that law, therefore I am denying your motion. Heather Bendel wrote down her reasoning verbatim from the card services teleprompter, knowing that her court watchers were being illegally blocked from the hearing by Judge Sandra Upchurch as seen in motions in Heather's docket. Now, Heather is submitting this exact same evidence to General Magistrate Alexander Alvarez. So when Heather files her suit in Florida Supreme Court against all elected officials that have managed this case are failing her minor children, Alexander Alvarez will not be able to say he never saw this long-term evidence of child neglect and abuse in his possession. He does now, and as an elected official that swore an oath to protect victims and children in Florida Circuit 7, he has a legal, moral, and ethical obligation to act immediately on this evidence as taxpayers have faith and trust that he is doing the job responsibly to protect citizens. I'll just keep going on because you've already chewed up 20 minutes of my time. Exhibit C, 2020 Illinois police reports and investigations showing the history of physical abuse Justin Serlick inflicted upon Thomas Serlick, Bianca Serlick, and Heather Bendel, where Illinois State Attorney Michael G. Nerheim failed to do his job to protect us from Justin Serlick by not prosecuting him, even though Thomas and Bianca very clearly state they were physically abused by Justin in these reports. These reports also indicate that the minor children were asked if they knew Justin Serlick attempted to rape Heather Bendel in the RV camper July of 2020, and the children told the investigators they were feet away from Justin attempting to rape Heather Bendel in the middle of the night. Exhibit D, Daytona police report from Justin Serlick's residence at 333 South Landvale Avenue, Daytona Beach, Florida, 32114, dated 3/23/2024, where Heather Bendel attempted to pick up her minor daughter, Ariana Serlick, that Heather Bendel had full legal custody of, but Daytona PD would not do anything without a current Florida court order. So all they could do was take a written statement for the event. Police report for Ariana Serlick in a car accident where still a minor that was actually Heather Bendel's legal responsibility, but was never made aware of this accident by Justin Serlick. Exhibit E, Daytona police report from Justin Serlick's residence at 333 South Landvale Avenue, Daytona Beach, Florida, 32114, dated October 30th, 2022, where Thomas Serlick attempted suicide in Justin Serlick's care and was Baker acted due to severe bullying at Mainland High School, proving that Thomas Serlick has ongoing mental health issues that Justin Serlick is very clearly neglecting. Thomas Serlick is 17 with an 8th grade education with an alarming amount of unexcused absences. This is child neglect and child abuse. Justin Serlick never divulged this alarming information to Heather Bendel or this court. What else is he hiding? Exhibit F, current grades of the children in Volusia County schools and evidence that Justin Serlick removed Heather Bendel's access to Thomas Serlick's grades and attendance after he was transferred from Mainland High School to Richard Milbourne Academy in January 2025. Heather Bendel has been completely ignored by VCS since this occurred, even though Florida Supreme Court law allows Heather Bendel to have the exact same access as Justin Serlick regarding the children's education, where they are illiterate and failing with a 1.0 GPA for years now, because this court system is failing my children while protecting this abusive person. He's not a man. He's not a human. It is important to know that Thomas Serlick was transferred to Richard Milbourne Academy only after Judge Sandusky Upchurch chastised Justin Serlick in the January 8th, 2025 hearing after Heather Bendel voiced her deep concerns over her children's education and unexcused absences. This is more proof that Justin Serlick is actively deceiving Heather Bendel and this court regarding the minor children's well-being. Exhibit G, the children's previous grades in Heather Bendel's care in Illinois from 2018 to 2020, showing they were high honor students with perfect attendance, proving that they were excelling in their academics until they were dumped in Daytona, Florida, with Justin Serlick, where they are being neglected and abused by him. How a child does in school is a direct reflection of their home life. Exhibit H, please see the 3/2/2025 YouTube video where Justin Serlick is walking viewers through Justin Serlick exposing the minor children to drugs and drug paraphernalia on TikTok. This video can be found, and then I've emailed the link to you. It's in the evidence, and it's all over my nonprofit Justice for the Serlick Children YouTube page for the entire world to see. So no one, not a single person involved in this can say that they didn't know it existed. Exhibit I, please see the 3/2/19/2025 YouTube videos where Heather Bendel's minor children left her 3 voicemails from phone numbers 386-610-3749 and 386-610-3750, where they're very clearly demanding to speak to me as their mother, Heather Bendel. You can also hear 8-year-old Charles Serlick in the second voicemail say, "Let's just go see her." And then Thomas Serlick tells him to STF you. Heather was driving on I-4 when the calls came in and that she did not recognize. And when she called the numbers back, no one answered. This evidence and proof that the minor children want to speak and see me. Voicemail number 1, the link. Voicemail number 2, the link. Voicemail number 3, the link. It's on my nonprofit for the whole world to see. Yet again, no one can say they don't have access to those voicemails. Exhibit J. Please mute yourself, court watchers. In all of these photos, you will see the last photo Heather Bendel took of her minor children in August 2020, before they were governmentally kidnapped from her, then dumped in Daytona, Florida, where Justin Serlick has withheld any and all contact since August 2021. Photo of Ariana Serlick with Heather Bendel, Peter Arnold, and her boyfriend Briley at the Solar Bears game at the Kia Center in Orlando, February 28th, 2024, where you can see Ariana was smiling and happy to spend time with her mother for the day. It was a week later that Rick Brown was hired by Heather and told her that she indeed has legal custody of Ariana since the Illinois case closed December 28th of 2023. Obviously, Ariana was not afraid of her mother if she went in the same car as Heather and Peter over an hour away to a hockey game where she earned a Guinness World Record that day. Photos of Heather Bendel having lunch dates with Charles Serlick at Palm Terrace Elementary in spring 2024. A note Bianca Serlick wrote Heather Bendel and had Charles Serlick pass to Heather at one of their lunch dates, spring 2024. Photos of the children's property being stored and then brought down from Illinois to Florida in July 2024. Heather has been paying to keep her children's property safe since January of 2020. Photos of Heather Bendel and Peter Arnold's 4-bedroom, 2-bath house with a full upstairs loft and a huge in-ground pool, showing that our house is ready and more than sufficient for Heather Bendel's minor children to live. Exhibit K, abusive and harassing emails from Mary Serlick, Justin's mother, to Heather Bendel in June 2022, and then abusive and harassing emails from Mary Serlick, Justin's mother, to Heather Bendel and Peter Arnold in 2025. This also includes Mary Serlick's flying monkey, which is a psychological term, Laura Stiles, that has been abusing, harassing, and stalking Heather Bendel and Peter Arnold for over 3 years now. Exhibit L, Heather Bendel's Florida Department of Education Educator Certificate that you can only receive after you've been successfully hired and fingerprinted with a Florida public school. Evidence that Heather was hired by Volusia County Schools and worked at New Smyrna Beach Middle School as a 7th grade science teacher, where she was responsible for 121 other people's children. This is proof that Heather Bendel has 0 criminal record, and there is 0 legal reason to keep Heather Bendel from her minor children that are being neglected and abused by Justin Serlick, other than collusion and corruption in this court case. Heather Bendel's University of Wisconsin Parkside transcript showing she is currently in her MBA program in marketing with a 3.8 GPA, yet her children have had a 1.0 GPA in Volusia County Schools for 3 years now. Exhibit M, evidence that Heather Bendel formed a nonprofit organization in dedication to her children called Justice for the Serlick Children, to help other victims of family court corruption and to raise awareness to this very serious issue. Heather hopes to connect with other families that have fallen prey to this heinous act of injustice. Please see our mission statement. Exhibit N, evidence that Heather Bendel is actively seeking out State of Florida House of Representatives Chase Tremont to discuss this very alarming and concerning situation, as the children in Heather Bendel are his constituents, and the public has a right to know what is happening with children in Florida Circuit 7. Evidence that Heather Bendel is actively seeking out State of Florida Senator Tom Wright to discuss this very alarming and concerning situation, as the children in Heather Bendel are his constituents, and the public has a right to know what is happening to children in Florida Circuit 7. Evidence Heather Bendel is now a candidate for Florida Senate District 8 and House of Representatives District 30 in the 2026 election. Heather Bendel has sent out a press release on March 10th, 2025, where she explains she will let her constituents determine which position would allow her to best serve the communities. Exhibit O, evidence Heather Bendel has been attempting to communicate with Justin Serlick to work things out, but he has her blocked on all forms of communication since October 2020. Again, based on all the above evidence, this is extreme child abuse and child neglect. Heather Bendel is now requesting on the record that criminal actions be taken by Florida Circuit 7 against Father Justin Serlick, and this court immediately allow Heather Bendel full authority to pick up her children and get them the help they desperately need as this has gone on long enough and these children need intervention immediately. All of the above evidence needs to be forwarded to the Florida State's Attorney's Office for immediate review, as the evidence of exposure to drugs alone is a criminal offense. Now that I've gone through the summaries, you need to actually look at the evidence that was intentionally blocked from my docket. Yet I outsmarted whoever it was that intentionally did not put it in my docket and e-filed it yesterday. So now it actually is. So Mr. Alvarez, I suggest you start doing your job that we, the taxpayers, pay you to do, and look at that evidence that's in my docket, 140 to 146 DINs.
I do have a copy of your exhibits, Ms.
Good,
Bennett.
start looking at it, because I will be suing you.
Are they exhibits A through O?
That's correct. I just read through all the summaries of each one.
Okay. Anything else you wanted to say?
How do you sleep at night? How do you live with yourself?
Ms. Bendel?
Knowing that you are putting my children in danger. How do any of you sleep at night? I want to know that.
Ms.
Because
Bendel,
I will be seeing you in Supreme Court. And this is my mission, to work my way up to Washington, D.C., to bring corrupt people like you down.
Ms.
Start
Bendel,
looking at the evidence, and you need to start actually protecting my children now.
Mr. Serlick, do you have any objection to my admitting the exhibits A through O into evidence at this time?
I do have some objections. She's bringing up stuff that has been addressed in previous
Okay.
courts.
I'm just asking about the any objections that you have to any of the documents. I trust you have the documents in front of you.
I don't have them immediately in front of me, but I'm aware of them, yes.
Okay. Do you have any specific legal objections to my admitting any of those documents into evidence?
I do. She hasn't had
state your legal-
rights
State your
under
legal
the
objection.
what was that?
State your legal objection to their admissibility.
I'm not an attorney. I don't claim to be, so I don't know the legal jargon.
Unfortunately, Mr. Serlick, the law requires me to treat you as if you were, to treat both parties as if they were represented by attorneys. I can't give you any preference or allowances.
Well, they are
understand you-
inaccurate. They're false and inaccurate in some aspects because they
Where's your
only show her side of the story. It is a one-sided bit of information.
Okay, well, that objection goes not to their admissibility, but to the weight of the evidence. The court will consider the documents and accord them the weight the court believes should be accorded the documents. So I'll go ahead and admit them. Did you want those admitted consecutively, Ms. Bendel?
Yes, please.
Okay.
I put them in a specific order for a reason. In
Okay.
my 140 through 146, they ended up getting out of order because of whoever processed them through the e-filing. But the 138, which is 372 pages or 382 pages, sorry, it keeps getting jumbled up because people are intentionally not doing their job. But the original 138, DIN 138, is the order in which I want them to be reviewed. I spent a lot of time putting it together in a specific order for a reason, because I've been building a much larger case this entire time.
Okay. Did you want to testify anything further?
I think all of the evidence I've submitted is more than sufficient to give
Okay.
me my children immediately. So I suggest you start actually doing what us taxpayers are paying you to do.
All right, Ms.
And
Bendel.
protect my children.
Ms. Bendel, Mr. Serlick is entitled to cross-examine you based upon your testimony. So, Mr.
Go ahead.
Serlick, do you have any questions that you want to ask Ms. Bendel?
I do, specifically in regards to the rape charge that you keep building up. We went to court on that in Illinois, correct?
Just ask
we
it,
didn't.
just, Mr. Serlick,
No, we
just,
didn't. It
Hold on,
look
Ms.
at the
Bendel.
FOIA report, Justin. Look at the FOIA report.
Ms. Bendel.
You
hold
know
on.
exactly what you were doing to me while I was an Ambien for years. You know exactly what you were doing. Pulling my pants down, raping me, cleaning me up, and then putting my pants back on. You sick fuck.
Ms.
You
Bendel,
know what you've been doing to me. And I pray another woman never falls prey to you. No amount of prayers is going to save you. You are going straight to hell.
I request that you find her in contempt.
Ms. Bendel, I understand this is an emotional subject, but
Wanting to
please-
cross-examine me, there's my response. I'm sorry that he doesn't like it, but any woman would feel the same.
Ms. Bendel, this is a court proceeding. Please refrain from using profanity and speaking
Sure,
out of
but we're
turn.
talking about rape, which is a very sensitive subject.
I understand, Ms. Bendel, but
Good,
this is a
then let's
court
move on. Let's move on.
Repeat your question, Mr. Serlick, and just ask a question. Don't testify. Just ask the question, and then Ms. Bendel, I'll give her an opportunity to answer. Go ahead, sir.
So what does it state on DIN 41 that the state of Illinois, DCFS, and the courts stated who gained guardianship of the children?
Okay, Justin, I don't know what delusional world you're living in, but those two guardianship orders, the very first line, A, says it has an expiration date of 2022 and 2023. Those are not custody orders. That is temporary guardianship. In fact, the orders actually say temporary on them. Family court is the only court system that has the ability to give you custody. And if you actually bother to read the 2-page order from April 27th of 2022, you will see that, first of all, it doesn't even give you custody. It just gives you rights to their education, religious beliefs, etc. The word custody is not actually used in that 2-page order at all. On page 2, it actually says, my rights to my children are reserved. I'm sorry you do not have a college education, but the word reserved means it is to be heard at a later time. Reserved does not mean terminated. So I suggest you start actually reading and comprehending the orders in which you are speaking of, because it's very clear as to why our children are illiterate. They can't read or write, and clearly neither can you.
Mr. Serlick, do you have another question?
I have one. I'm going to produce an example.
Mr. Serlick, just ask the question.
Okay.
Mr. Alvarez, this is ridiculous. I am tired of playing this fake game. We need to start addressing my children's safety and welfare before one of them end up on the news dead.
Mr. Serlick,
Again, I request to find her in contempt. She continues to talk over me, and we can proceed no further until she is reprimanded.
Like you're not talking. You are chewing up my 1 hour. This is my hearing, not yours. If you want a hearing against me, you need to actually do what you're supposed to do and schedule hearing time. You
Ms.
are wasting my hearing. If
Ms.
you don't
Bendel.
have any further questions, we need to move on.
Ms. Bendel, I'm asking Mr. Serlick if he has any other questions. Do you have any other questions, Mr. Serlick?
I do. While you were working, you said you were working at the school. Why weren't you paying child support?
You mean the illegal contempt order that was signed under the table with no due process and
No.
evidence?
No.
That is illegal, and I'm going to be suing Judge Stasia Warren and your attorney Serena Baldacchino. You don't even know what's going on because your mommy is running the show for us. You have no clue what actually happened. That contempt order should have never happened. That is not how child support works. Child support means that they're actually in my life. If they're not in my life, that means my rights were terminated and I don't pay child support. You don't get to not have any contact with your kids and pay child support, Justin. That is not what the law states. You need to learn the laws if you're going to actually try to control me. Can we please move on? This is ridiculous, and this is intentionally wasting the court's time.
Do you have another question, Mr. Serlick?
I do. Do you know what states on DIN 41 that says about your visitation? It is to be determined by the facilitators,
It is
meaning
to be
a supervised visitation.
Those DCFS cases are over. They were closed out 3 years ago and they are expired. Illinois DCFS does not control the family court system. You are living in a fantasy world. That is not how family court works. Two separate entities. Line A of those two guardianships order that give you temporary guardianship state This order expires on 2022. This order expires on 2023. Therefore, the one that expired December 28th of 2023 means that from December 29th, 2023 on, I literally had legal custody of Ariana Serlick because you did not bother to do your job, which was to transfer the Illinois case to Florida and then present evidence to Florida Family Court to gain custody of said children. You need to get out of your fantasy world because you, Mary, and Ira Serlick are the only ones living in it. The rest of the world lives in the real legal world. And that's why I have been building a much larger legal case for years now, and I will be suing every entity and walking away a millionaire. So let's
You have another
stop
question,
screwing
Mr.
around and actually dealing with the fact that my children need help now.
No, I have no further questions because she's not going to cooperate.
Okay. Ms. Bendel, did you want to call your witness?
Yes, please.
All right, let me admit Mr. Arnold. You could unmute yourself, Mr. Arnold.
Can you hear me?
Yes, getting a little echo, reverb. All right, please raise your right hand if you support it. Do you solemnly swear or affirm? I can hear myself, Mr. Arnold. Is there any way you can?
Give me a second.
Sure.
Trying to deal with my audio. Okay, try. Is this better?
All right, we'll try it again. Do you solemnly swear or affirm that the testimony you're about to give in this case shall be the truth, the whole truth, nothing but the truth? So help you God.
I do.
Please state your full name.
Peter John Arnold.
Okay. And what is your relationship to Heather Bendel?
I am her fiance. We've been in a committed relationship for almost 2 years.
Okay. And what is your address, sir?
Domestic partners registered with my company.
Okay. What is your address, sir?
1709 Queen Palm Drive, Edgewater, Florida, 32132.
All right. Thank you. Ms. Bendel, go ahead and ask Mr. Arnold questions. Ms. Bendel. You're mute. You muted yourself, Ms. Bendel.
All right, Mr. Arnold, have you met any of my children?
Yes, I have. I met your daughter Ariana when we took her to an Orlando Solar Bears hockey game. We spent the entire day or most of the day with her and her boyfriend. And then I met your youngest son, Charlie, when I went with you to meet his guidance counselors and principal at his school. And they brought him in to the meeting to see you and to talk to you.
And what was said in that meeting, and who else was present in that meeting?
So in that meeting, it was you, the guidance counselor, I believe her name was Miss Sweet, the principal, Miss Troutman, of Palm Terrace Elementary School, had also come into the meeting and was present for most of it, and myself. And then after you had your meeting with the guidance counselor and the principal, they brought Charlie in and probably talked to Charlie for almost an hour.
And what was discussed? What were some things that my son said to us unprompted?
Ms. Bendel, it would be hearsay for Mr. Arnold to testify about what the children said. So, don't ask any questions that elicit what the children said.
So, Mr. Arnold, what did Charles Serlick say to us that day?
You're talking about Charlie, your son, right?
Yes.
Okay. It's hearsay, inadmissible hearsay, with regard to what the child told Mr.
Okay,
Arnold.
I'll just tell that Charles Serlick said that,
Ms.
he
Bendel, Ms. Bendel, this
wanted
is,
to come live
Ms. Bendel,
in
hold on.
front of
This
the
is direct
principal
examination.
and
Hold on.
counselor.
This is direct examination of Mr. Arnold. This is your opportunity to
Well,
ask a question.
you're legally not allowing him to say what he needs to say, so
He can't
it's not
testify as,
hearsay when he was witness to that.
Ms. Bendel, he can't testify as to child hearsay. If you have other questions that are not,
Mr. Arnold, what have you been witnessing Justin doing to myself and my children the last 2 years?
So I'm getting into a different room away from my speaker.
okay.
Clearly there has been a long emotional toll that the past 5 years has wreaked across your lives. I would like to say, with regards to the visit with Charlie, it was a very positive visit. He was visibly excited to be able to see his mom when we were there.
Mr. Arnold, can you tell me a date and time? When did this occur? I'm just trying to get a time.
I don't remember the exact date, but I believe it was in March of 2024.
So about a year ago?
Yeah. And I know, so I was present at that first meeting, and then I'm familiar with that Heather had additional meetings with Charlie, which are reflected in the pictures that she's provided, or that I've been told she's provided. I've seen where Heather has attempted to communicate via email and text messages with Justin to try to come to a resolution. I was present with Heather and her attorney, Mary Jane Henderson, when her attorney had explained to us that she was attempting to resolve things prior to having to go to court, and everything just got dragged along. In the past 2 years that I've been with Heather, I have seen the emotional reaction she has to seeing pictures of her kids when they come up on Facebook memories. We have been going through all of the property that was in storage in Illinois that Heather has brought to Florida that has all of the kids' belongings and clothes. And I have seen when she opens a box, and for example, just the other day, she opened a bag and found the children's swim trunks and swimming goggles. She collapsed to the floor crying because that was the last time. She has pictures of the last time those kids were wearing that. And in that picture, the kids are smiling and happy. And there is zero reason why this should have gone on for the last 5 years the way it has. Clearly, she's a mother that loves her children, regardless of whatever her personal issues between Justin and herself. She absolutely loves her children and deserves to be able to communicate freely with her children and have them be part of her life. It's become absolutely clear in 2 years of getting to know Heather that's the case and the reality. And from the interactions, when I was in the guidance office with Heather and meeting Charlie, it was clear he also wanted her to be part of his life.
You have another question, Ms. Bendel, for Mr. Arnold?
Mr. Arnold, in previous hearings that you were present for, can you please tell Mr. Alvarez what Justin Serlick was using as a reason to keep any and all contact with my children and I?
I was questioned about whether or not you would be a fit parent as being a single mother. I wanted to make 2 points to that prior. When I was questioned on that subject earlier, I made it clear that single mothers can absolutely be quality, caring parents. But I also want to make it absolutely clear that you're not a single mother. I'm your partner. I'm here to support you, and I'm here to support your children.
In those previous hearings,
Ms. Bendel, I'm having a little bit of trouble hearing you.
in those previous hearings, so I'm specifically referring to the December 17th, 2024 hearing, just before Stasia Warren recused herself. What did Justin Serlick say in that Zoom hearing where you were a witness to?
There was a comment about if the kids came to live with you in a house that you didn't have any claim to, somehow that would be some sort of a problem if something were to happen to me or if our relationship were to sour. And regardless of whatever your living conditions are, that alone should not prevent you from having contact with your children. Secondly, as far as support you would get if this is our house, we live here together, we have adequate space to be able to provide caring, loving space for the children, where they can do their homework, where they can play and have fun. There is nothing about our house that should block you from being able to see, talk to, communicate, and have your children in your life. Additionally, I have, if the concern is if something were to happen to me, would you be able to provide support for the children? If the worst were to happen to me and I was to pass away, I have extensive life insurance through my job and separate policy. I also have a trust, and the house is to be named in the trust with Heather as a beneficiary on the trust.
In your opinion, do you think that Justin is putting the needs of the children first, which is Florida Supreme Court law?
I think any parent that expects to fully shut the other parent out of the children's lives is doing the greatest disservice to the children. Having myself been a child of divorced parents, it is critical that children get to interact with their parents, both parents, if needed. And for one parent to sit there and say, you're not paying child support, so you don't get to see them at all, that is a direct violation of Florida law. You can't hold child support as the sole reason for withholding contact. And it's just morally wrong. There are parents that get into situations where they cannot afford to pay amounts of child support. And there are situations where the amounts ordered don't reflect the reality of financials that are submitted to the court. And I've witnessed that here in this case, as I've helped you prepare your financials. Part of the reason I helped you prepare your financial statement was I am a financial advisor with Edward Jones. I'm licensed as a stockbroker and an investment advisor. I also hold a enrolled agent license with the IRS. So I was helping you prepare your financials. So I'm very familiar with what your financials were. when the latest hearing in regards to the child support occurred. And it's my understanding that the court is supposed to take into consideration those financial statements that are submitted, but there is no way, based on what I'm familiar with, what the current orders are, that they considered Heather's financials at all.
Did you see
Any
the
other
email
questions?
from Paige Russo back in November of 2024, right after that contempt order was signed by Stasia Warren without due process? Did you see that email that was submitted into evidence?
I have seen that email you're referring to.
And what does that email state?
The email, which was sent out after my understanding that the contempt order was signed, was requesting you to provide copies of your financial affidavit to them because they were unable to open the file, which, to be clear, indicates that because they told you they could not open the file prior to them sending that email to you, and they sent the email after the contempt order was signed, they never considered or reviewed your actual financial affidavit prior to them submitting a proposed order to the court, which was then summarily signed, as far as my understanding.
What, Mr. Arnold, just so I'm clear, when you say they, who are you referring to?
I was just about to ask that as well.
So the attorneys representing Mr. Serlick,
Was that Ms. Baldacchino?
I believe so.
Okay.
And then Paige Russo, I believe, is an assistant at the Rice Law Firm.
Okay.
Yep, so
Thanks.
Serena Baldacchino of Rice Law Firm and Paige Russo of Rice Law Firm and Judge Stasia Warren all committed felonies in November 2024, where they signed
Ms.
an
Bendel, don't
contempt
testify.
order
Don't
under the
testify.
table, no due process without doing any of my financials, as well as Florida Supreme Court law requires that I have a copy of Justin's financials as well, which I have yet to receive in the last 5 years. Not one time have I gotten Justin's financials. So all of this time,
Ms. Bendel,
these
this is
courts
direct
have been
examination
ordering
of
me
Mr.
to pay
Arnold,
child
though.
support illegally under
Ms.
the
Bendel?
table as a means to keep my children from me, which is all federally illegal, which is why I've been building a much larger.
Heather, do you have any more questions?
Thank
I
you.
do
Ms. Bendel.
not. Mr. Alvarez, when am I going to be able to pick up my children?
Mr. Serlick, do you have any questions for Mr. Arnold?
Just remember, there's a lot of court watchers watching this, Justin.
If anybody's asking me questions, I can't hear anything.
Mrs. Serlick, do you have any questions?
Yes, I do. Sorry.
Go ahead.
Do you know the reason why the children were taken into DCFS custody?
I do. And I say that because I have reviewed the DCF reports. I've been shown the emails and text messages from the case manager from Camelot Care, which is a privately contracted agency. There's two specific things that were cited. Okay. Those two specific things were that one of the children made a report that they had moved a certain number of times in the prior year. And the other aspect that they were being removed was claiming Heather's mental health was a concern based on statements that you reported to the investigators that Heather was had mental health issues. Those were the two reasons in the reports that were cited over and over and over again. There were no reports of physical abuse until long after the case was started. And the only physical abuse allegations that were ever mentioned in any of the reports were an allegation that Heather provided gummies, which were potentially marijuana gummies. Though I know in the reports, Heather's side of the story was that those were melatonin, which is a over-the-counter sleep aid. Those are the issues that's what is referred to over and over again in all of the DCF reports. It was that they moved. Now let me also remind the court, it is in the docket, but the reason for the moves multiple times was because Heather had sought out domestic violence shelter help. This was also as COVID pandemic was progressing across the country. The domestic violence shelters placed Heather and the children in hotels. And because of the COVID pandemic, one hotel would close and then they would have to move to another hotel. That was a significant part of the reason for the moves that were being cited as reason for the Illinois DCF case to progress.
So you stated that it was because of multiple movings, not because she was taken into custody and the children were living in a garage or a basement, and then there was no other person there to be able to take care of her, of the children.
Okay, so I'd be more than happy to discuss the incident that you're referring to based on my knowledge of what happened and the police reports that I have read. So the incident that you're referring to, let's be clear about what happened, okay? Heather had been a victim of assault by one of the other residents of that house. That lady was arrested. Heather was making arrangements to move out of that house. Prior to Heather being able to get out of that house, the lady who was arrested was able to file through the Illinois court system an order of protection against Heather. Okay. When Heather showed up to pick up her belongings from that house, she was escorted by the police. At some point, the police officer left the scene. Then the other residents of the house made a report that Heather had come inside the house, somehow violating the order of protection. Heather was arrested for that reason of violating the order of protection. Now, let's be clear about what happened with that case, if this is what you're going to ask, because that case was completely dropped by the state attorney once it became clear that the residents of the house were in fact lying about all of the statements about Heather going into the house. Not only was that case dropped, but I have read the reports where it was expunged from Heather's record, meaning it's as if it didn't happen because of how evident the lies were from those folks. Now, let's also be clear, because I have also seen the text messages between Mary Serlick and the other resident of that house, where Mary Serlick was coordinating with the residents of the house to try to get a case that Heather had filed against him in small claims court in Illinois to proceed. That small claims case ended up getting found in Heather's favor.
Mr. Arnold, can you give me just a reference point, a time frame for the incidents or the events that you're speaking about?
So they would have been in early October of 2020.
And these are events that occurred in the state of Illinois, correct?
Correct.
Okay.
The incident where Heather and the children had, in an effort to get out of the situation of bouncing between hotels, Heather had moved in with a friend of hers, an acquaintance who Heather had known for some time. The gentleman was not a stranger. He was not somebody she met on the internet. He had been to their house before as a friend. He offered space in his home. They had a unfinished basement that Heather and the children were able to bring their furniture in and arrange and make it comfortable to live, so that they had somewhere other than hotels to be bouncing between. It wasn't until after they had moved in that it became clear that the situation was not an ideal situation with the other other resident of the house, which was the mother of Heather's friend, who was apparently, based on the communications I've seen, friends with Justin's mother, Mary Serlick. And there's evidence that Mary Serlick influenced the mother, who was a resident in that house, to trigger all of what happened to happen.
Any other
So
questions?
you agree that the inability of having, you stated that she was arrested and that there was no one there to take the kids. So with that statement, are you agreeing that her children were stolen from her?
That was one part of the overall storyline.
That's not what I asked. I asked that by not having a parent.
Let me finish answering your question. There was that night when the Heather was arrested, one of Heather's friends was able to come to the scene and take the kids for the night. And Heather picked the kids up the next morning when she was released.
I really want to know, Mr. Serlick, how does something that happened 5 years ago have to do with our children having a 1.0 GPA and you're exposing them to drugs on TikTok now? This was 5 years ago. Why are we even talking about something that happened 5 years ago? We're supposed to be talking about right now.
Ms. Bendel, if you have a legal objection to a question that Mr. Serlick is asking, then state your
I have a lot of objections to this whole damn case.
I have to, again, request that the judge, Alvarez, you enforce decorum of the
right
court.
now in your care.
Do you have any other questions?
Stop playing the victim, Justin. You are not the victim. I am. Why did I have to get into domestic violence shelters to begin with? What did you and Mary Serlick do exactly 5 years ago, March 22nd, 2020? What did you and her bend over me, screaming at me to do in front of our children in Port Orange, Florida?
Ms. Bendel. Ms. Bendel, stop talking.
You told me to kill myself. That's what. That's how all of this started. You and your psychotic mother tried to get me to take my life. You should be in prison for the rest of your life just for the amount of abuse you've inflicted upon me alone. Not considering the fact that you kicked Thomas Serlick in the ribs 3 times, then physically picked him up and threw him through his bedroom wall, and then turned to me and looked at me and said, "Don't let me do that again." You control your behavior. You control your actions.
Mr. Serlick, do you have any other questions?
Then every single morning you would grab Bianca by the ankles, yank her to the hardwood floor.
Questions because I'm being interrupted and he's not following the decorum of the courtroom.
I'm tired of this. Something that happened 5 years ago has nothing.
It is the entire reason we are here today. You refuse to take actions for your choices.
Mr. Serlick, go ahead and ask Mr. Arnold any remaining questions.
Again, do you feel that when DCFS has to come in to a situation to take the children because it is an unfit and unsafe environment, is that considered stealing the children
5 years.
or kidnapping the children?
5 years ago, we're talking about right now.
Heather, I can answer this question if it pleases the court.
Stop obsessing.
Go ahead, Mr. Arnold.
There are a lot of reasons why DCF agencies come into contact with children and families. Okay. Just because DCF came into contact with a family does not mean that should be the end all be all permanent end of relationship between parents and children. Okay.
That's not at all the question.
There is a lot that went on in this case. You're aware of it. Heather's aware of it. I'm aware of it. I have read through thousands upon thousands of pages of reports and emails and text messages. There were numerous statements made by you yourself. These are documented in the DCF reports that led them to proceed in part on the way they did. So you told direct lies to DCF investigators, okay, about Heather's mental health. You made statements, these are written down in the DCF reports, that Heather was bipolar, which she is not. And that was somehow the reason. Again, this was also, you know, in following through everything, okay, the allegations that have been levied in this case, while they were investigated by DCF, and DCF made administrative findings, nothing was forwarded for criminal prosecution because there wasn't enough evidence for criminal prosecution from DCF. There's clear evidence that
Mr. Serlick, don't interrupt him. He's giving his answer.
Okay.
there's clear evidence, you know, in if you just follow through all of the documents in this case and all of the reports in this case, that what it really boiled down to coming up to the end was who had enough money to pay for the better attorney is really what happened in this case. When it all came down to it, DCF closed out all of their cases, forwarded it to the Illinois Family Court. The Illinois Family Court requested, since at that point, all of the parties, with the exception of Ariana, were living in Florida. The Illinois Family Court requested both Heather and Justin to move the case to Florida court. My knowledge of the situation, based on when I met Heather and when she was seeking to retain her attorney, Mary Jane Henderson, Heather was told multiple times in Florida by multiple Florida attorneys that she had to be a resident of Florida for a full year before she could open a family case in Florida to be able to get the Illinois case transferred to make a final decision on the long-term arrangement between Heather and Justin. The 2-page order that was filed in Illinois when Heather was not present, which is documented in the order, so you can just read the order and see Heather was not present, but it was signed, giving Justin time sharing and parenting decision making with Heather's rights reserved. That means in the terms and the language of the court that the court needs to make a decision at a future time. And in an effort to get in front of a court to allow a court to make that decision as far as Heather being able to have time with her children, that's what has brought the case to where it is. And that's why this case is in front of you, Mr. Alvarez, is because for years since that order was signed, I believe in 2021 or 2022, Heather has been attempting just to get in front of a court to resolve the issue of the word resolve or reserved.
Anything else, Mr. Serlick?
In a yes or no response, is DCF taking children from a custodial parent kidnapping?
Yes.
Okay, thank you. No more questions.
Ms. Bendel, any redirect?
Yes, actually, thank you, Justin, for asking that. Mr. Arnold, since we started networking with other people, most notably a woman named Karen Tusani that you met at a Chamber of Commerce event, she has a nonprofit called Legal Abuse.
Just ask the question, Ms. Bendel.
What has that charity event that we went to last year led us to since then, and what we've discovered and found out across this nation?
So that event was somewhat eye-opening. That particular charity specializes in raising awareness for abuse of the legal system by domestic violence parties. At that event, you and I were connected with multiple other individuals that have eerily similar stories where DCF agencies stepped in and made decisions that were not reflective of reality and have ruined lives. Since then, we have also connected with multiple other nonprofits and other groups that have as a way to connect other families that have had similar issues where a DCF agency has stepped in, and these are groups across the country, and it has become shocking and eye-opening at how much this occurs. That when I first met you, we thought your situation was so unique and so isolated. That was the only way you could sort of make sense of it. And since then, we've literally come across hundreds of other stories where similar issues happened, where DCF stepped in and removed the kids, and blocked access to the parents or grandparents, and it was not a situation reflective of the facts and the reality of the situation in the family's lives. There are multiple stories where a DCF agency stepped in and removed kids simply because the family was poor. And we've come across multiple.
Form of child trafficking?
Yes, so it absolutely is a form of child trafficking, and that's been made clear by the literally hundreds of other accounts that we've come across, and some of the actual other groups that we've come across, where there is a for-profit motive in some of these states. I know here in the state of Florida, it has made the news before, where kids are removed and then placed in specific situations so that, for example, the Florida State Children's Home, this was probably one of the most well-known cases here in Florida, where children are placed there and then the group managing the children receives money for profit from the state. These stories we've come across these stories all across the country.
Yeah, so some of the nonprofits that we've come across, one of the founders is actually a court watcher today for Survivor Center. We actually met her at Karen.
You have another question, Ms. Bendel.
So she is witnessing this. Another nonprofit we came across.
Ms. Bendel, do you have another question?
Mom's Fight Back in Colorado.
Bendel.
Stolen children by CPS out of California.
You have a question?
Bendel.
My nonprofit, Justice for the Serlick Children. So I want this to be on the record that children across this nation are being stolen from the actual parent trying to protect them from their abuser in the domestic violence situation, and then child trafficked so everyone in the system can make money off of them. The private agencies, the case
Ms. Bendel.
workers, the
Ms. Bendel.
GALs, the judges, the attorneys,
Okay.
the foster parents. Mr. Arnold, were my children child trafficked from 2020 to 2023, in your opinion?
From everything I know, a normal person reviewing it would 100% concur that it was a level of child trafficking that occurred. And I say that because the children were bounced between foster situations when within 1 month of the precipitating incident, you had obtained a 2-year lease on a home that was made ready for the children to move back into and be reconnected with you. And the agencies continued to make money, specifically in your case, Camelot Care, which is a private for-profit company. They continue to make money because their case manager who works for them continued to put in reports that you were not completing the services requested. However, there's also multiple reports and filings from your attorneys and multiple text messages and emails from you asking them to provide you a list of what was left to complete. And they never did. They never submitted anything to you. They just continued to tell you you hadn't completed everything so that the children could stay in their care and they could continue to make money. And that is documented in all of the text messages from the case manager, emails between the case manager and your attorneys. And I have read through all of it myself, so I've seen it myself.
Any other
And
questions,
in
Ms.
your
Bendel?
opinion, do you think that my children have benefited from all of this last 5 years, or do you think that they have a lot of trauma and mental health issues because of what has been occurring the last 5 years?
There is not a normal, sane, educated person on earth that could in any way say that your children have not suffered in the past 5 years from everything that has occurred to them. In addition to just what has occurred directly in your family case, I can speak to this as somebody who was raised in a state with a great education system and then being forced to move to Florida as a child and then attend schools here in Florida. Having been with you when we visited your hometown and seen the schools up there, and having seen the school records of your kids up there compared to knowing the schools they're in now here in Florida and seeing their current grades and academic records here in Florida, absolutely they have suffered a great injustice in their own personal educations by being by having to be moved to Florida and losing all of their connections between Boy Scouts and Girl Scouts and their education and support systems that did exist back in Illinois.
Any other questions, Ms. Bendel?
No, I think it's very
Mr. Serlick, do you have any other questions?
of what needs to be done next.
No, I have no further questions.
Okay. Thank you, Mr. Arno. I appreciate it.
Thank you.
Ms. Bendel, do you have any other witnesses you'd like to call?
No. When am I going to be able to pick up my children?
Okay. Let me turn to Mr. Serlick. Are you resting then, Ms. Bendel?
Right now I am, but I'll have a lot more evidence in the coming weeks as to what I was referring to earlier with the other tricks up my sleeve.
Okay. Mr. Serlick, this is your portion of the case. This is your opportunity to testify on your own behalf. You can also call any witnesses that are present here today.
Okay. I have only been following and doing as what I have been ordered by the courts. Any paperwork that I've given is what I have followed. And every single one of them has indicated that, yes, she could have supervised visits. She does not want to cooperate, and she is only fighting to get full custody back. When she was the sole reason that this whole thing happened and why the children were taken. Even when I worked with the agencies, when they got picked up to find them a singular home, Miss Bendel compromised that home and then forced the children into 3 separate different homes. And then other instances where, the phone calls that Miss Bendel references by Tommy, yes, because she put him into a panic attack and upset him because she was posting his personal information publicly in Facebook, and that drove him upset.
You're perjuring yourself.
He reached
right
out
now,
to her and she
what you're
refused to
referring
answer.
to is a police report. It's public record. That is not medical. You're perjuring
Ms.
yourself.
Ms. Bendel, if you continue to interrupt,
I'm
I'm
just
gonna,
pointing out what he's doing. He's perjuring
Okay.
himself, which is
You can-
illegal.
I'll give you a chance to cross-examine him, but please reserve any comment until then, okay?
Perjuring himself.
Go ahead.
I am doing the best that I can as a single parent, where
Then
the
why do they
other
have a
parent,
1.0 GPA? If
Ms.
you're doing
Bendel.
the best you can, why do they have
decorum of the court, please.
a 1.0 GPA?
Ms. Bendel, if I mute you, please do not unmute yourself. If you refrain
I
from,
want him to answer that question. Why do they have a 1.0 GPA for 3 years now?
Ms. Bendel, you'll have a chance to cross-examine him after he's finished.
Mhm.
Please reserve
tired
comment
of
and questions until
Not
then.
doing anything.
Go ahead, sir.
So I work almost at least 40 hours a week, and I have consistently done this for the entirety since my children, our children were taken into custody. Miss Bendel has chosen not to work. I don't know why. That's her choice, but she's still responsible for these children, and she's not taking any responsibility. She's just claiming the victim role.
So why
Over and over and
contact with them since August?
This is why she lost initial contact with her children.
Stop
During our
perjuring
first
yourself.
visit, she almost attacked me at the
Stop
visitation
perjuring
center.
yourself.
And from that point,
Justin, you've been
she
raping
has
me for
lo-
years on Ambien. You should be in prison.
Ms. Bendel, if you interrupt one more time, this is your last warning. If you interrupt one more time, I'm
Well,
gonna
then
place
maybe
you in the
he should
waiting.
start telling the actual truth. Because I'm telling the truth, he's not.
Okay.
So go ahead,
Again.
keep perjuring yourself. You're being recorded. You've got court watchers. This will be in my lawsuit against all elected officials. Keep perjuring yourself, Justin. Go ahead.
Go ahead, sir.
yes, there's been some difficulties, but you know, with everything that I've had to gone through, I have done it all for my children. I take care of my children. I do not abuse my children. I have now been assaulted twice by her attacks through DCFS stating that I am abusing the children. There is a Florida statute that states that that is illegal. You know, I am here to try to protect my children. And yes, I have absolutely no problems letting my children see her, but it needs to be in a DCFS supervised visitation center because I don't feel safe with her.
Anything else, Mr. Serlick?
No, I have nothing further to say.
I have plenty of questions, Your Honor.
All right, go ahead, Ms.
You
Bendel.
don't deserve it. Mr. Serlick, under what grounds do my visits with my children have to be supervised? There's no DCFS involvement.
Reference DIN 41.
Are you
It's
talking
stated
about
in there by the
expired-
finalization of the Illinois court said that you are supposed to have
Again,
visitated.
You
supervised
are referencing
visits.
a closed case in Illinois. Illinois has no jurisdiction down here.
Ms. Bendel.
Illinois has no, if you